I'm a big fan of killing the billable hour. Everybody that listens knows that. That's no secret. But also, as you and I were talking recently, for example, if we set flat fees, which many immigration attorneys have done, they probably set those fees based on the situation that existed at the time they set their fees, which might have been, in this case, a prior administration's rules. If I know this is the process, it takes these steps and this is how long and this is the situation, I might price it based accordingly. Well, now we have a new administration in here, and the process may have be completely changed. That could be a scary thought for some. And this is probably applying across the board, even beyond immigration, but it's just a great example of one. So, as a business owner, how should I be thinking about that?
There's an inherent conflict of interest um, about the money when someone hires you, but the rules allow for it. If the rules didn't allow for it, it'd be hard to practice law, right? So the question is, though, what happens after the representation begins? If you went back and renegotiated a fee, what kind of conflict might there be at that stage? Particularly if you're raising fees. It's one thing if you agree with the client to lower a fee for some reason. But if you're raising fees, of course, that's where the concern really comes in. The risk really would be most on a lawyer who's quoted a flat fee and says it's just all inclusive and they don't provide any exceptions in their engagement agreement. So let's assume for a minute that has happened. There was a DUI case that was taking place, and I think it was in DC. And so the lawyer had, lots of cases where they settled, negotiated, and it was quick, easy for the DUI. They would charge flat fees. And then all of a sudden, it had a case that was going to go into like a 2-week trial. And so the lawyer went to the client and said, I need to raise the fee. And the client said no. And then there was a dispute. In some way, the lawyer compromised the client's position. They got into ethics trouble because the ethics authority said it's a flat fee, a deal's a deal. It might have been appropriate for you to ask the client, but the client also had the right to say no. So I wrote a paper on this. It's called How to Ethically Change Fees Midstream. And one key question is whether the really specific conflicts at 1.8a apply. If you're in the middle of a case, you ask the client to change fees, particularly nobody's going to have a problem with lowering a fee, but raising a fee. Um, do the strictures of that rule apply, which means you'd have to advise the client to go seek their own independent counsel, give them the time to actually seek their independent counsel. The request would have to be reasonable. So part of what 1.8a would actually ask of you or require of you is to even ask the client about raising the fee needs to be reasonable. So one of the ways you could at least help out in that category would be to put in your engagement agreement something like we reserve the right to increase the flat fee based upon a change in the facts or law. You probably make it more elaborate than that, but at least say something. And so what we
Right.
found during the previous Trump administration, which prompted my article to be written, is there were lawyers who would quote a flat fee. They wouldn't have anything in their engagement agreements to allow them to raise the fee. Because as you know, part of the reason you like the flat fee is people want that certainty, right? So,
Right.
so one solution, other than maybe doing what I just described, putting some kind of provision that gives you the right to raise the fee, would be to charge a really high flat fee, has to be reasonable, of course, but a really high but reasonable flat fee. So the risk would be lower on the lawyer, but at least that client gets the certainty of what the fee is. And then another thing, I've heard, I think it was Greg Siskin who once said that you have to think about three things: the fees, the speed, and the quality. And you have to have at least two out of the three. So if you're charging a high fee, you better be fast and have high quality. So if you can
Yeah.
deliver both of those things, maybe it warrants charging a high fee, and maybe that's protection kind of built in. On the other hand, let's say you charge lower flat fees, you really need to be careful because what if a change happens? According to my understanding, during the previous administration, there were firms that were facing bankruptcy because they had quoted these flat fees that were on the lower end already, and then they didn't have provisions in their agreement to be able to raise uh, the fees. And there's a Florida ethics opinion that I like to talk about that says it's the opposite of what you would normally hear. You have to charge enough to do the case properly. So we talked about competence and diligence already. You have to charge enough money to do the case competently and diligently. So there's some people who call me and they feel as though they're doing kind of a public service But there is that floor that you can't drop beneath. So if you're, Kim Kardashian, who may soon become a lawyer, you don't have to charge any money at all. But for most of us, we have to charge enough money to do the case properly because we're in business to help people, but also to make money. We have to make some money to pay our staff and ourselves.